Thank you very much for the invitation. It is indeed a privilege for me to share the podium with Alan Borovoy, a champion of civil liberties, pioneer in the creation of human rights commissions, and a Canadian icon. I just want to say, as I begin, that I remember seeing Mr. Borovoy in a similar debate on police activities and how impressed I was. And it is with no small amount of humility and trepidation that I will attempt to respond to your able submissions on this very important issue today. This debate echoes a debate that we've had in Canadian society in the last few months, mainly following the complaints filed against Maclean's magazine with the Ontario, British Columbia, and federal human rights processes. Now, while all of these complaints have been dismissed, and this will be important in my submission, they have raised and put forward the issue of the interplay between the freedom of expression, which is the lifeblood of a free and democratic society, and the freedom from hate and the principles of equality and protection of minorities. And this debate is crucial. It is one about balancing rights, and I take note of the concession of Mr. Borovoy that freedom of expression is not absolute, and I do take this position. The courts have taken this position. The difficulty is balancing. The difficulty is finding that line. And finding that line and having this debate is very important for society. It's very important for the Canadian Human Rights Commission. It's one of the reasons I'm here to talk about it. And it is also the reason why the Canadian Human Rights Commission has commissioned Professor Richard Moon of the University of Windsor to look at all of the tools to deal with hate on the internet, to give us advice on whether the tools are, as Mr. Borovoy suggests, too broad, whether the process needs to be improved, and so on. And we are certainly very open to any way that the system can be improved. But in many ways, this debate is not new. 20 years ago, or almost 20 years ago, the Supreme Court of Canada dealt with this very issue in the Taylor case, and the CCLA, as an intervener, made some of the arguments that Mr. Borovoy has made today, that the legislation is too broad, that it is an undue limit on freedom of expression. What was the court's answer? Well, the Supreme Court split, and the majority found that the answer was a very narrow interpretation of hatred or contempt. The court started from the proposition that no right is absolute, that there is no hierarchy of rights. Rights don't take precedence over others, and that when you're in the presence of a conflict, you need to go forward with a very careful balancing. And this balancing was done, as I say, with an extremely narrow definition of hatred or contempt. What did the court say on this? They defined hatred or contempt as communications that are likely to expose individuals to extreme ill will, detestation, enmity or malevolence, unusually strong and deep-felt emotions of detestation, calumny, and vilification by virtue of their race, religion, or other prohibited grounds of discrimination. This isn't controversial speech or offensive speech. This is speech that is of such an ardent and extreme nature that they are essentially